Hello, good good afternoon from our colleagues in Brazil, and good evening from our colleagues in Europe, and maybe good morning for our colleagues in US or other countries. My name is Bernardo. I'm here with my partner Luiz Paulino. We are talking about the patent term adjustment, the PTA, which is so far an idea that we have to try to compensate the patent office delays in granting patents in view of the Supreme Court's ruling that states that the 10-year term from the grant date is not constitutional, right? Just oh, hold on, technical. Let me share. We prepare some slides. I'm gonna share with you now. Okay, Luis. Okay, or okay. So first things first, just a little introduction so that we are on the same page, make sure that we are on the same page. Well, the Brazilian IP law has an article, the Article 40, that allows, sorry, that allows for two possible patent terms. The main provision of this article grants patents a term of 20 years from the filing date, while the sole paragraph of these articles provides a specific term of 10 years from the granting date. Well, that's the whole idea. The idea of this additional term, this 10-year term from the granting date, would be to compensate a possible delay from the patent office. That was the idea of the lawmaker when he created these two possible terms for patents here in Brazil, because and there is no criteria to have one or another. Basically, is that the longest of these two should be the term of a patent here in Brazil. The idea is to guarantee that the patentees can enjoy at least a minimum term of 10 years from the granting date. That's what our IP law used to establish. Well, the idea of this provision would be not to be the 10-year term provision, not to be used on a regular basis. The idea was to be used on a few cases when there is a particularity of this case that the patent office, in view of this particularity, took a long time to conclude the examination and therefore to grant the patent. But that was not the case. As we can see, this graphic, it shows that the 10-year term almost became the rule instead of the exceptions. From a long time, I mean, at least in the beginning, in 2010, the year of 2010, the majority of the patents in Brazil were granted with the 20-year term, which this data shows that the patent office was doing its job fast. It was granted the patents with an expedite fashion. However, this proportion between patents with the 20-year term and patents with the 10-year term start to change. From 2013, the majority of the patents granted in Brazil, here in Brazil, had the 10-year term instead of the 20-year term. This ratio achieved its peak in 2015, because almost, I mean, basically 3/4 of the patents granted here in Brazil had the 10-year term, which shows that the patent office was not being quickly to examine the patent application and grant patents. And basically, because of this high amount of patents with this 10-year term from the grant date, that a constitutional tell have been filed before the Supreme Court against this rule that established that the patent would have a minimum 10-year term. The first one was a constitutional challenge filed by AIPPI, a Brazilian association that represents the generic companies here in Brazil. This constitutional challenge was dismissed because the Supreme Court understood that AIPPI would not be entitled to pursue constitutional challenge, will not meet the criteria provided by our law. However, the prosecutor office here in Brazil understood that AIPPI's arguments were right. Therefore, this prosecutor office, who is entitled to file a constitutional challenge against the sole paragraph of Article 40 of our IP law. Okay, and continue to the graphic. The graphic shows that okay, the patent office its, let's say, this backlog peak on in 2015, but after that, the patent office started to improve itself. The number of patents with the 10-year term were decreasing, which shows that the patent office was examining application much quicker than before. And in 2019, when the patent office started what we call this program to tackle the backlog, almost 50% of the patents were granted with the 20-year term. And last year, the vast majority of patents were granted with the 20-year term, which shows that the 10-year term were in fact become the exceptions as the lawmaker foresee when issued the Brazilian IP law. But this was not enough for the Supreme Court that eventually ruled that this provision of the IP law establishing that the patent can have a term of 10 years from the grant date is not constitutional. Okay, and therefore, in view of this decision from the Supreme Court, the Patent Office is now only grants patents with the 20-year term from the filing date. Okay, this was what we can say a perfect storm, because this constitutional challenge was decided by the Supreme Court in the middle of the pandemic here in Brazil, the COVID pandemic. There were a lot of discussion. It was political arguments that I wouldn't say that dominates the discussion, but it had a great impact in the discussion by the Supreme Court justice. And at the end of the day, basically they consider that it would not be reasonable to have this 10-year term because of 2 points. It's not possible to see when the application is filed, when the patent would expire. They understand that because it's 10 years, but as the patent office sometimes takes more than 10 years, sometimes 15 years, it will not be possible to know when the patent would expire. Okay. But the bright side that of the Supreme Court ruling is that the Supreme Court just understands that their decision would have a great impact on the already granted patents. Because, I mean, in theory, I mean, as a general rule, the Supreme Court's ruling on constitutional challenge has ex tunc effect, means that the provision of a law that's considered unconstitutional must be considered as never exist. So we are talking about several, I would say more, 10 of thousand patents with the 10-year term would have to have the term reduced to the 20-year term. That would create a major impact here in Brazil, because we are talking about royalties, license agreement, and from one day to another, all these patents have the term reduced. So the Supreme Court ruled that, well, this my decision has the effects of my decision is from now on, meaning that all patents granted with the 10-year term can keep this term. Okay, that's what the Supreme Court ruled. But the Supreme Court rule provide an exception to this ruling. This exception is, of course, for the pharmaceutical patents. The Supreme Court ruled that, okay, the pharmaceutical patents with the 10-year term cannot keep this term. The patent office must reduce the term of these patents so that let's say all the pharmaceutical inventions can be available to the public and everybody can use in order to fight the pandemic and other disease. Okay, that's what the Supreme Court ruling. Unfortunately, this ruling binds the patent office. Even though the patent office might not agree with the Supreme Court decision, the patent office must comply with the Supreme Court decision. Therefore, the patent office is now granting patents with without the 20-year term. All patents granted here in Brazil are now limited to the 20-year term from the filing date. And for the pharmaceutical patents, the already issued pharmaceutical patents, the patent office is republishing these patents with the 20-year term from the filing date. However, it's not an easy job to review all the granted patents in Brazil in order to detect the ones that are related to a pharmaceutical invention or, according as the Supreme Court's ruling, health-related equipment and materials. So the patent office creates a criteria to detect these patents. The criteria are divided in five criteria. The first one is the one that looks for detecting the patent that covers a pharmaceutical invention. Because here in Brazil, for pharmaceutical patents, before the patent office grants a pharmaceutical patent, Anvisa, which is the Brazilian regulatory agency, must consent to this grant. Okay. I mean, nowadays not anymore because the Brazilian Congress removed this provision from the IP law, but this is a recent removal. So back then, the patent office, before issuing the patent, needs to forward the application to Anvisa. So Anvisa gives the consent to the grant of this patent, and therefore the patent office grants. So basically, the patent office did the following: all patents that when they were application, I sent to Anvisa, which means that I understand that this invention is a pharmaceutical invention, will have the term reduct to 20 years from the filing date. The criteria number 2 and 3 basically try to detect the patents that covers health-related equipment and material. The patent office use the IPC classification. And the slide shows the classification that the patent office use. We have this criteria number 4. That's basically all patents that are mentioned in a lawsuit. The patent office will specifically check these patents in order to reduce the term of this patent. And the first one is a specific type of patent that we have in Brazil that's called the certificate of addition. It's basically, let's say, a continuation in part as we have in the US. It's basically an improvement of an invention that cannot survive for the already granted patent. I mean, in terms of novelty or inventive step. But there is an invention here. There is an improvement. So we can file the certificate of an addition in order to try to seek coverage for this improvement. Basically, is that the patent office is now reviewing the certificate of addition in order to see if they relate to a pharmaceutical invention or a health-related equipment or material in order to reduce the term of this patent. Just a little bit of numbers so that we can have the job that the patent office has to perform here in Brazil after the Supreme Court's ruling. The Supreme Court's ruling was, if I'm not mistaken, on May 12. When the judgment set to conclude was on May 12th of this year, and after that, 2 weeks after that, the patent office started republishing patent application, the patents with the new term, with the 20-year term from the filing date. So far, the patent office has published more than 5,500 patents here in Brazil, which was huge numbers. I mean, we were crazy here in order to inform the clients and to suggest alternatives to try to handle, especially because, as you might think, the criteria created by the patent office encompass patents that are not 100% related to a pharmaceutical invention. There are sometimes inventions that are for the veterinary field. There are some types of invention that is not per se a pharmaceutical invention, but can be used in the pharmaceutical field. So we have to inform clients to review the patents because we could fight for the 10-year term. I mean, we filed several motions, let's say motion for reconsideration to the patent office, explain that, well, your examiner, this patent does not cover per se a pharmaceutical invention, but also cover other aspects of the invention. I mean, veterinary use. So the patent should keep the 10-year term, or at least have two terms: the 20-year term from the filing date for the embodiment related to the pharmaceutical field, and 10-year term from the grant date when the embodiment is not related to the pharmaceutical area. Well, we need to wait for the patent office decision. The patent office has not yet decided any motion for reconsideration in order to see that. But based on our conversation with the examiners, the patents director of the patent department, they say that, well, the patent office is, at the first sight, the tendency is to accept all the arguments in order to keep the 10-year term when acceptable. It makes sense because, I mean, as we're talking about an exemption from a Supreme Court's ruling, we must interpret this exemption narrowly to make sure that anyone that it's not specifically meets the criteria created by the Supreme Court can keep the 10-year term. Okay. But moving forward with the presentation, I mean, that's the main goal here, is to talk what we can do to try to compensate for the patent office delay. As I said, the patent office, unfortunately, takes a long time to issue a Brazilian patent here. This time is, thankfully, is being reduced. Every year, the patent office takes less and less time to grant a patent. But the ones that were granted, that was granted that peak that I show in the graph, I mean, there are several cases that the patent office took more than 5 years to simply start the examination, and sometimes even more, sometimes 10 years to start the examination. There is a delay here that's solely responsible, that the patent office is the solely one responsible for this delay. And this delay prevents the patentees from enjoying the constitutional right to exploit a patent invention for a reasonable term with exclusively. So we need to do something here in order to compensate the patentees from the patent office delay, in view as taking into account that the Supreme Court ruled that the 10-year term from the grant date is not constitutional. Okay, and the idea that we came up so far is the patent term adjustment. That is an alternative that we believe that's reasonable to fight for a term longer than the 20-year terms from the filing date. The only downside here is that Brazil does not have a statutory provision for patent term adjustment, meaning that it doesn't make any sense to request this term adjustment to the patent office. Because here in Brazil, the patent office as a government agency cannot do anything that the law, I mean, perhaps I should say the other way. The patent office can only do what the law authorizes. As the law does not authorize the patent office to adjust the term of a patent, the patent office cannot adjust the term of any patent. So we need to go to the court and ask the court to declare, to order the patent office that we are entitled, the patentee is entitled to a patent term adjustment in view of an unreasonable delay from the patent office to grant the patent. Now I give you, Luiz, the floor that will talk a little bit more about this.
Thank you, Bernardo. Can you hear me? Because I think your image was freezing here, but I think it was because of my internet connection. But now I think I reconnected and I can see everyone very well. So, well, my name is Luiz Paulino. I'm Bernardo's partner at the firm. I do litigation with Bernardo with focus in IP. And as Bernardo was explaining, we are facing now a very different scenario than we used to have for the last 25 years. So in the last 25 years, applicants that were waiting for more than 10 years, sometimes 15, 18 years, to have its patent granted by the WTO, were entitled to have a minimum term of 10 years counted from the date of grant. However, now, after this decision issued by the Brazilian Supreme Court, all the patents will have the 20-year from filing, regardless of the time of the delay that caused by the WTO in order to grant the patent. And fortunately, I may say, our firm came up with the idea of filing PTA court actions before the court as an alternative to mitigate this delay and the damages that were caused by the WTO by delaying the examination of applications. As Bernardo explained, unfortunately, we don't see much. We don't think it's worthwhile to ask the WTO in many circumstances to grant an adjustment in the patent, because, as Bernardo said, the WTO as a government entity will only do what the law says. And we do not have statutory provisions granting patent term adjustments in Brazil. So what is the basis of this patent term adjustment judicial measure or claim or lawsuit that we have been recommending our clients to do? First of all, assuming that the WTO took several months or years, a reasonable time to examine the application, and that this delay was caused solely by the WTO. In other words, it was not caused by the applicant. The applicant is entitled to have, according to the Constitution, a reasonable time whenever it addresses a request to the administration, to the public administration. So patent applications should be examined according to the Brazilian Constitution within a reasonable time. And what is exactly a reasonable time? It's not very easy to determine that, because we don't have, as we said, a statutory provision detailing how an adjustment would work in Brazil. However, we have guidelines in the industrial property law and in the federal law that guides the administration in the administrative proceedings, establishing how many days or how much time the administration should take to act whenever it is requested by the applicant. For instance, the Brazilian IP law provides that the Brazilian Patent Office must act within 60 days when the application is ready to be examined. That is, when, for instance, the applicant files the request for examination, the WTO would have 60 days to start examining the patent application and to issue a decision, an office action, or an opinion on the patent application. The federal law number 9784 of 1999 also provides that all the government agency must issue a decision within 30 days. These 30 days may be extended to additional 30 days if the administration needs. Another provision that also guides the Brazilian Patent Office in the timing of the examination is the Article 62.2 of the TRIPS agreement, which says that members of the TRIPS agreement must comply with reasonable procedures in their respective countries. So those are.
And Luis, if I may, just one comment. I mean, besides this legal provision that you mentioned, it's also important to compare with the other countries. I mean, in order to show that the unreasonable delay from the patent office. I mean, because we can say, the U.S. and patent office, the European patent office took just 1 year or a few months to complete the examination. The patent office take let's say 6 years to simply start the examination. So it shows this unreasonable delay.
Yes, yes, that's true. And in Brazil, we are very comfortable to say that, unfortunately, the Brazilian Patent Office take an unreasonable time to begin examination, because we're not talking about months, we're talking about several years counted from the date we filed the request for examination. In some cases, we have more than 6 years that the PPT will take to start the examination. So this is really, we say that we are very comfortable on one hand, and sad on the other hand, to know that our patent office takes that much time to examine patent application. So as you see, the right of the patent holder to seek the patent term extension arises, first of all, of the Constitution, which guarantees to the patent holder the right to exploit a patent for a reasonable term of exclusivity. And one thing must be very clear, because sometimes we even heard during the hearings before the Supreme Court some misinterpretation of the Brazilian IP law and of the right of the patent holders. But the right to enforce a patent in theory only begins with the grant of the patent by the PPTO, not by the filing, not with the filing of the patent application before the patent office. The filing of the application must be considered as an expectation of right, but only the granting of the patent, of the letter patent, entitles the holder to enforce those rights. So this unreasonable time that the BPTO takes from the filing of the application until the grant cannot be regarded as a correct exercise of rights of the holder. And this is an important information in Brazil, and this consideration is not only a question of interpretation. Our courts interpret that way as well. So an example, for instance, if you have a patent application in Brazil and a competitor or a third party is infringing, is reproducing the subject matter of your patent application, unfortunately, you cannot file a patent infringement action against this third party. You may send a letter to make this third party aware that a patent application is pending. You may tell this third party that in the future your patent may be granted, but you will not get an injunction or a preliminary injunction hindering this third party from violating, from infringing your patent. Many decisions have been issued by the Brazilian court in this sense. And it's also important to say to you that we have a sort of a compensation in the law. I wouldn't say it's a compensation, but our law in the Article 44 of the IP law provides that the holder has the right to claim damages retroactively, counting from the date of the publication of the patent application. So if your patent was granted 10 years or 12 years later, you would have in theory the right to claim damages for the past years if a third party, a competitor, infringed your patent. However, this right is limited to a 5-year term, meaning that you will only be allowed to claim damages according to our courts, according to the case law, for the 5 past years that your patent was infringed, not for the 8 or 10 years that are gone. So in other words, this exercise of claiming damages, it's not a complete one. It has a serious and damaging limitation, which are those 5-year statutory terms. So I'm saying that, and Bernardo knows, because there are many or some allege that if your patent application has a delayed long examination by the BPTO, that wouldn't matter because you have the right to claim damages. But the exercise of this right is very, very limited, very unlikely you will not be compensated as you should, and therefore our law privileges the exercise of the patent instead of the damages. And finally, you should never transfer the patentees the burden to seek compensation for a wrongdoing that the BPTO alone caused. Still on the patent term adjustment basis or rationale, it's true that our firm came up with the idea, or at least move forward with this idea, but we must recognize that the answer to this problem, this issue that we are facing right now, which is a delay of the BPTO on one hand, and many patents having their terms, especially in the pharmaceutical field and the medical field, having their terms immediately reduced by the Patent Office, by the Supreme Court. This idea, actually, we must recognize that was also mentioned by the decision of the Supreme Court itself. So the Supreme Court understood that the automatic 10-year term counted from the date of grant was unconstitutional, was against our constitutional. But on the other hand, it also praised that the PTA system that many countries have around the world, statutorily speaking, is much more appropriate than the 10-year term for grant that we used to have in the law. Because the PTA system is analyzed and applied on a case-by-case basis. So you need to see first if there was a delay, who caused the delay, in order then to measure the adjustment you may seek. From this decision on, we decided that we could move forward with the PTA court actions, and also because, and regardless of the fact that there is or not an statutory provision in the law allowing PTAs in Brazil. Why? Because the Brazilian law or the courts or the judge must examine your request whenever you allege that you had damages, that your right was jeopardized. The courts have the obligation to examine, even if there is if the law is silent about a specific request, the court must find a way to examine your request and to rule it and to provide you with the rightful compensation. Federal law number 4,657 expressly states that if the law is silent, the judge may rule according to the analogy, the customs, and general principles. Another principle that our law has is the concept of the non-liquid. The court can never decline to rule a case, a request, due to an alleged gap in the law. It must find a way to provide you with a remedy, with a response, a fair response. And finally, our code of civil procedure, or our code, civil code, also provides that an injured party must be compensated for any offense that the party has received. So those are some considerations of the patent term adjustment rationale. Remembering that it's really, I really recommend anyone to read, although it's a long decision. I don't know who have the courage pages of this decision of the Supreme Court, but it's really interesting how they even suggest, how they praised for the PTA system. Okay. To move on to the next slide. Okay. Okay, we still have a few minutes. And well, all the information that we are presenting here is public, so it may be accessed by anyone from all around the world, not only in Brazil. So just to make sure that we are sharing public information here. As far as we know, only 4 PTA court actions were filed so far in Brazil after this decision of the Supreme Court. All the 4 were filed by our firm. The first lawsuit filed was a lawsuit filed on behalf of Johnson & Johnson for a patent related to the drug Stelara. And it was filed in the end of July this year. At trial, the Johnson & Johnson requested to the court on a preliminary fashion 2 things. One thing is for the Brazilian Patent Office to publish in the Patent Gazette and on their website the sub judice notice, which means that the Brazilian Patent Office has to disclose that the term of this patent is under judicial review. This was one of the requests. Another request was a preliminary injunction to stay the effects of the decision of the DPTOs, which reduced the term of the patent. Those 2 requests were initially denied by the trial judge. Actually, the PI request to stay the facts of the DPTO's decision was denied by the trial judge, and that led Johnson & Johnson to file an interlocutory appeal to the Federal Court of Appeals in Brasilia. After analyzing on a preliminary fashion the interlocutory appeal, the appellate judge, Marinho, decided to grant Johnson & Johnson the PI request and ordered the DPTO to publish a decision stating the effects of their administrative decision, which reduced the patent, which reduced the term of the patent. The importance of this decision isn't just because of the fact that it was favorable to Johnson & Johnson, because the court ordered the DPTO to stay the effects of this decision. But more importantly than that, the decision in a certain way welcomed this initiative, welcomed the right of the patent holder to seek for a PTA in Brazil. It's also worthwhile to read the appellate judge's decision to see that she understands on a preliminary fashion that it is possible to seek a patent term adjustment in Brazil. So this was the first court action. Immediately afterwards, Johnson & Johnson, or almost at the same time, a few days later, filed a second court action for the patent related to the drug Symphony. The PI was initially also denied at the first level, which also led Johnson & Johnson to file interlocutory appeal. This interlocutory appeal is still pending. No decision was issued in this sense. So those were the two first court actions. We have also two additional court actions, one filed by AstraZeneca, AB, on September 9, also this year, and another last month so far by Chiesi, it's Italian pharma company, on September 10. I'm not getting into the details of each court action because we don't have enough time here. Of course, Bernardo and I are glad to share with you further details if you're interested. Later, you just contact us. It will be a pleasure to share this information with you. Well, I think we can jump to the last slide.
No, just one comment, okay. Luiz, if I may. As you explained, Johnson & Johnson has requested this preliminary injunction, or preliminary request to suspend the effects of the patent office republication of the patent. This request was not presented by Chiesi and AstraZeneca, but these companies, they request that the court orders the patent office to publish in the Brazilian IP Gazette the information that the term of their patents are under judicial review. This is a very important request, and so that in order to show to third parties that, well, you're not free to exploit a generic version or biosimilar of this medicine. So this is a very, very important request. And I mean, that's what they believe. Perhaps they understand that they should not go for this PI, but at least letting other partners know that the term is under discussion, is under judicial review.
Yes.
Sorry, Luiz.
Yeah.
Go ahead.
No, thanks for this. Is a very important information, making third parties aware of the efforts of the patent holders in seeking the PTA is I think very, very important. And this is the reason why we requested the sub judice notice before the BPTO, because anyone may access the BPTO's website. They publish those decisions in the patent gazette, also accessible to anyone. So this is really important. And finally, just to take this opportunity, in addition to the PTA, patent term adjustment lawsuit, we have also other alternatives to deal with the backlog and to deal with the decision of the Supreme Court and the scenario that came afterwards. Two possibilities that the patent holders have and holders of marketing approval have in Brazil are the data package exclusivity lawsuits. Although we are facing some difficulties before the courts to enforce the data package exclusivity for pharmaceutical drugs applicable to humans, it's still an alternative. We'll still recommend our clients to try this alternative whenever needed. Another possibility also possible in Brazil, and the rationale is similar to the PTA, is the PTE, the patent term extension, which is due whenever the regulatory agency entity delayed the granting of a marketing approval request. In this case, it's also possible to seek a PTE before the courts. Again, we don't have statutory provisions similarly to the PTA, but there are sound grounds to file such a lawsuit. Nowadays, another recommendation that we have been presenting to our clients, and I think we even had a specific meeting before us about that, is fast track examination. You may file for fast track examination before the BPTO in order for the BPTO to expedite the analysis of the patent. Sometimes, or many times, the fast track request, the administrative fast track request, is not enough. So there is also room to file a writ of mandamus, which is a legal measure before the courts to have the patent application examined quickly. But this is also a possibility, more than a possibility, is a recommendation that we usually do whenever we believe that the examination is delayed, which is necessary nowadays, since you have only the 20-year from filing term. We also have to consider filing court action aiming at preserving the right from a given contract. So if you have a contract, an agreement in force that foresees payment of royalties, it's very important to pay attention to that and to eventually access the need to file for a court action claiming for adjustment of the term of the patent, so that the terms of the agreement of the contract may be enforced correctly. Finally, the last recommendation that we have been presenting to our clients is, of course, the advocacy, which is, we believe, the correct way to changing the law. In fact, just a disclaimer, Bernardo and I was discussing prior to this meeting that the constitutional challenge in the AIPPI 529 wouldn't be necessary if our government had given the BPTO examiners and the patent office the right conditions to fight for the backlog. We believe that the correct way to deal with the backlog was to find a way to accelerate this examination by hiring examiners, by making the examination more effective, instead of filing a court action, instead of going to the judiciary. And another possibility is also amending the patent law.